we're going to have, let's look at our contract that we're using. So we go to page 17. That is our subject to contract, subject to purchase contract. Let's see if I have one that's done on the screen. No. Yeah, no. All right, well, here we go, right here. Okay, so here goes the subject to purchase contract. All right, guys, so the parties to the agreement, self-explanatory. Most of you guys have done, hopefully have done a purchase and sale agreement. Okay, so the parties to the agreement are going to be the buyer and seller. I'm going to go down to total purchase price, paragraph 1. If you look down there, you see you're going to put an earnest money deposit, whatever that is that you want to put down or not put down. It does not actually take, the contract is still a valid contract regardless of whether you or not you put earnest money down. I typically like to put some type of earnest money down because if you put a nominal fee down, even $10, I put, if I put $10 on there, I want to physically write that individual a check. I want to write them a check for $10 and hope that they actually deposited that check or cash that check because I know they're in. Okay, they cashed that check, that formalized it for me. Okay, balance due at closing, if there's going to be a balance due. So in this particular case, we were giving the individual some money. All right, so we gave them, giving them $100 because basically what we're doing is we're giving them $3,000 as a part of us taking over their property subject to, in this case. So balance due at closing, $2,900. All right, we go down, we're taking their property on E, subject to the existing financing. They have a loan with Wells Fargo, and you can see the loan number, the interest rate, whether or not that includes principal, interest, taxes, insurance, and everything else. And that loan balance or approximate loan balance is $98,000. All right, so our total purchase price is $102. All right, down there in paragraph 2, it says basically seller will pay all closing costs to include all the things you see there, guys. Now, what I tell people sometimes, particularly if you decide you want to use this contract, I mean, guys, this is just a basic generic contract. I mean, it works well, but you may not want to use it. You can make your election as to whether or not you want to adopt using this contract. Again, get it reviewed in your state or location, make sure it's good where you're at. All right. Now, anything in here, guys, this is actually a pro-buyer contract. It does slightly slant towards the buyer. Okay. So it's saying seller will pay all closing costs. Now, guys, you have to read your contracts and know what's in them. If you know that you're giving a seller a contract that says that they're going to pay all the closing costs, and that may be a point of contention, then you either can line through it or whatever and don't worry and not worry about it. Okay, don't get into a big argument. If they don't say anything about it, fine. If they say something about it, then what you're going to do is go all the way on this contract. You're going to go back to paragraph 18. All right, and in paragraph 18, it tells you this is all the additional terms, conditions, or whatever. So you can write up in here, buyer. You can write closing costs as customary. So if you write closing costs as customary, that means that you're going to pay the things that a buyer normally pays, and the seller pays those things that a seller will normally pay in the transaction. All right. No need to get huffing and puffing about it. And if you know you're getting a good deal, you may want to scratch that out from the beginning because you don't want to cause a point of contention. All right. And so I'm not going to read all the verbiage in the contract. You can go through and read the contract because we'll be here all day, forever. But basically, guys, what I'm going to tell you with this is that with all of your documentation, make sure you go through and read your contracts and understand your contracts. I think one of the biggest mistakes that most of us make as investors is that we have contracts and documentation that we don't know what it says. And the worst time to find out, you got a tenant in your property and something happens and you're going back trying to look through your lease to see whether it's covered. Okay, you should know what's in your contract. All right, so let's make sure that we exercise ourselves in a professional manner. All right, so we go out to the property, we sign in the purchase and sale agreement. Going back to this, go back to the slide now. All right, hold on one second. Let me go back. All right, so let me point out just a couple of things in this contract. In this contract, in paragraph 11, it actually gets into default and attorney fees. So it talks about the remedies for what happens if the seller tries to back out or if you actually try to back out. And there's initials that are going in there so that we've agreed to this stuff up front as to what's going to happen. All right. We've agreed that the seller is going to leave the property in a broom swept condition in this contract and that they're going to provide us with access to the property. All right. Paragraph 14 says that we're telling them from the outset in the contract that we're taking their property subject to the existing financing. This is important, guys. This is very important because you're letting them know up front. So this is initial disclosure. I'm not buying your contract. I'm not buying your house by traditional means. All right. So we're buying it subject to your existing financing. It says that the loan, we're not assuming the loan. This is not a formal assumption of the loan, and it tells you when you're actually going to commence making payments. All right, and that you're going to make all monthly obligations on the underlying loans and property taxes, association fees, and everything else. It says right here that the seller is aware. Seller is aware. I don't want to highlight, but it says the seller is aware that this loan will not be satisfied in full at closing and may continue to appear on seller's credit file. You told them this up front in their contract. It says that seller will provide buyer with loan payment booklets and written permission to contact the holders of any debt securing the deed of trust on the property. It says that the seller will execute a limited power of attorney to give you the ability and authority to operate on their behalf pertaining to the subject property. It also says that both the seller and the buyer acknowledge that the deed of trust securing the property may contain a due on sale provision, giving the lender an option to call the loan immediately due and payable. All right, and they may ask you about that, and you'll tell them that, just what I said earlier. Typically, the bank has, this is a paragraph that's in all loans that basically says the bank reserves the right to call the loan due and payable. But how many of us know that, if you sold your interest to your wife or you sold your interest to your brother or your cousin, that would be on you. So if they do that, then of course we have to provide remedy in that situation should they do it. We've never seen it done. All right. We don't have that happen. All right. But we have to let you know that it can occur. So you're basically just going to talk to them through that. If you were buying it and they were providing owner financing, you would do a purchase money note. All right. So you would, if they were providing financing to you, you do a purchase money note. In the contract as well, you have the ability down here in paragraph 16 to do an affidavit and memorandum of purchase and sale agreement. So guys, most of you guys have done some deals. You know that oftentimes you may have a seller that wants to flake out on you. You may want to go downtown and record a memorandum of this purchase and sale agreement to put the world on notice that you have a contract on this property and you're trying to protect your interest in that contract. All right, paragraph 17, assignment, says that you have the right to assign this agreement. All right, now guys, I'm just going to tell you, this is me. Typically, I don't do any assignments on subject to properties. There are some folks out here that teach that, and they teach you that you go out and you do a subject to, and then you find somebody and assign it to them. I personally don't do that because when I do a subject to, my reputation is on the line. And ultimately, at the end of the day, I don't care what kind of assignment you did. If you went somewhere and you sold that seller on this transaction, ultimately, if something goes bad, they're coming back looking at you. And I don't want to be in that process. But there are some people that teach that. You get in where you fit in is all I got to say about that. I don't do that. All right. And I'm not going to tell you to do that. And I would advise you not to do that. All right. That's stated clear up front. All right. Paragraph 18 gives you some things, guys. So this is some weasel clauses, subject to partner's approval. So basically you could almost back out of the contract subject to, because your partner didn't agree with what you were doing. If the final balance shown by the lender shows a lower principal balance, then the purchase price shall be reduced. So basically, guys, what you're doing is you're buying yourself possibly a reduction in price if the loan balance is actually less, okay? And this is already written in the agreement. It's also letting them know that if they have an escrow shortage or escrow or whatever, they would actually be responsible to pay that, all right? It says that the buyer reserves, in paragraph C, it says the buyer reserves the right to assume or originate new hazard insurance and be refunded on any unearned premiums. That means that when you buy the property and you put in your insurance policy in place, if they get, because their insurance is going to be canceled, when that check comes back, that's your check, okay? You let them know you're going to secure that check. I want to go back, because it also talks about buyer may take possession of the property upon acceptance of this offer for the sole purpose of making improvements and or showing the property. So you see all that, but and then of course you got your full understanding. Everybody read the agreement. They have the right to go take it and seek legal counsel and all that good stuff. But what I want to go back to, let's see. I want to go back to where it says commence payments, guys, commencing on September 1st, 2014 in this illustration. I want you to understand something, Dave. You can come to me. Guys, when you buy a property subject to, I want you to understand something. When you start saying the date that you're effectively going to start making payments, all right, this may actually buy you a couple payments or so, all right? So we contracted the property right now in April. We just contracted the property today, did a purchase and sale agreement, and we say that we're going to start making payments June the 1st. Everybody hear what I just said? If you say you're going to start making payments June the 1st, what's the first thing that seller's going to say? And you may say you're going to close on May 1st. We're closing May 1st, and we're going to start making payments on June 1st. All right, so we're going to close on May 1st or April 30th, and we're going to start making payments on June 1st. Now your seller's going to look at you and say, wait a minute now, how are you going, you're going to have to make the payment for May. You're going to close and you're going to be responsible for that payment. No, you're not responsible for that payment. I want you to remember this, because now this can also help you in negotiation. Maybe you get something else for this. Mortgages are paid in arrears, not like rents. Mortgages are paid in arrears. You know, when you pay rent on April 1st, you're paying to live there for the month of April. When you pay your mortgage on April 1st, you're paying interest on March's payment. So mortgages are set up where you're paying backwards. So basically, if the seller makes that payment on May 1st, they're actually paying for April. And you explain it to them. You know, Miss Seller, you know, mortgages are actually paid in arrears. So the payment that you're actually making on May 1st is actually for you having lived here for the month of April. And I'm sure you don't expect me to pay for you having lived here, do you? And then you can explain it to them. Okay. Now, if they want to argue and huff and puff about it, and it's a good deal, maybe you just leave it alone, or maybe you trade them out with something else. You know what, Mr. Seller, no problem. We'll go ahead and make that mortgage payment. I tell you what, I know you said you was going to take the refrigerator, but if you leave the refrigerator, then let's call it even. Okay. And then we move on to the next thing. All right. But remember that mortgages are paid in arrears. All right. We good on that? Okay. So going back to the steps on the subject two again. All right, we're going to locate it, the seller, and negotiate the purchase price. We talked about that. Get the contract, the purchase agreement signed, to give the seller a list of documents we need to finalize the sale. We call that the house papers. We're going to prepare our trust agreement. Okay, we're going to prepare our trust agreement. Remember, guys, you're probably going to take possession, or you're probably going to do your purchase and sale agreement as ABC Properties, maybe. Okay, and remember, before closing, you're going to call your closing attorney and say, we're taking possession, we're buying a property and we want to have it titled in a trust. And the name of the trust is XYZ. All right. So that's what's going to be taking title to the property, the trust. All right. We're going to have the seller deed the property to our trust. And then I got there, you see where it says assignment of beneficial interest, to use or not. I talked about this yesterday. We are not doing it by virtue of assignment of beneficial interest. You're going to have them deed the property directly to your trust. All right, directly to your trust. You do not want to use an assignment of beneficial interest, and I'm going to get into telling you why right now. All right, so this is what it looks like. If you do it this way, is the way we're going to do it. This you want to have the seller deed the property to you as the investor in your trust, and then you're going to start making payments the way that that it used to be taught, or some gurus still teach it this way. Is basically what they tell you is that the seller's going to deed, you're going to form the trust, or you're going to make the trust, and it's going to be pretty much their trust. So they deed the property to their trust, but you're going to appoint the trustee. All right, you're the one that had all this documentation prepared, and we're calling it the Smith Family Trust for the most part, and you have your trustee appointed. And basically what you're doing is you're going to have them actually assign their beneficial interests to you. All right. So in this case, we're not doing that. I'm just illustrating this to you. And I'm going to tell you, if you get somebody that tells you to do this, because I know some of you that have paid for this workshop have already sent me your documentation, and we have had this conversation. So now I'm going to tell you up front and personal right now why you didn't want to do it this way. Okay. All right. So I told you guys on yesterday just a second. Let me find you something, because I want you to thoroughly understand where I'm going. Guys, remember when we spoke on yesterday? And you remember that slide I just showed you? Y'all remember this lengthy reading of a lawsuit yesterday? This is mine. Okay? This was presented directly to Ain't Nobody Bad Like You. All right. And one of the primary reasons that this was actually able to go through the action that was taken is because I actually did that transaction like I just illustrated to you. All right. So basically what happened in this particular situation, I bought the property subject to, the seller deeded the property to the trust, and they assigned their beneficial interest over to me. 4 years later, they decided that they wanted their property back. Now, if I start getting mad, y'all just hold on, because I get mad all over again, because this was a nightmare. All right. I had their property for 4 years. When I met with them, they were 4 payments behind, $900 a month, 4 payments behind. Okay. The wife called me. I went out to the property, looked at the property, decided that I could buy the property and I would take the property over subject to. And we agreed that I would buy the property. They sold me the property subject to. The wife called me intermittently several times during the time period that I had the property, because she saw other properties that we had on our website. So she would contact me and say, Tony, how about the house over here? What about this house right here? Now, they were divorcing when I met them. They were separating, okay? Couldn't stand each other. Even when we were doing all the paperwork, they just wanted to get this behind them, didn't want to have a foreclosure, all right? 4 years later, they saw the property on my website because I had a tenant in there that had told me that he wanted to move, and he had given me a 30-day notice that he was moving. And because he was doing an option to purchase with me, I had a good relationship with him, and I told him that, okay, well, I tell you what, he was an over-the-road truck driver. I said, if you allow me to be able to show the property, because I know he kept it clean all the time and he was gone more so than not. I said, if you allow me to show the property during this 30-day period, and I'm able to get somebody in the property, it's a possibility I can give you some of your option payment back. And he said, that's great. I don't have a problem with that. I trust you. So I put a lockbox on his house. And he was, like I said, over-the-road truck driver traveling. And so one day, I get a call early in the morning as I'm out and about that says, yo, hey, I answer the phone. Hello? Yeah, this is Mr. Jones. Yeah, you bought I'm the one you bought the property from a little bit ago. Well, I just wanted to let you know you no longer own our property. And so I don't know what you need to do, but you need to get you need to get your person out of there. And if you got any questions, you can call my attorney. Click. Okay, so he gave me attorney information. I'm driving like, what in the world is he talking about? So I veer off and go to the property. So let me go out here and see what the heck is going on. So I get to the property, and sitting on the door, there's a letter. There's an envelope written on an envelope, on the back of an envelope, that says that this property no longer belongs to ABC Properties. And if you want to get your stuff, you can contact us at XYZ. So basically what these individuals did was they saw the property on my website and thought that the property was vacant. The husband and wife had reconciled and they were back together again. And because the loan was still in their name, they considered it to still be their house. I don't know what kind of screwy way they could do that. So they saw the house and decided that they were going to break in. So they actually broke into the house, and I believe they thought that the property was vacant because I had a rent-to-own sign in the yard. So they broke in the house, packed up all of the tenant's belongings, and put all his artifacts, all his stuff in one room, piled everything to the ceiling, because they were going to move in on top of him. They're going to just put everything in one room and start moving everything else into the house. And whenever he comes to get his stuff, he just go in one room and get it. So I get there and see the note on the door and get on the phone, and I actually call their attorney. So I called their attorney and I asked him, I introduced myself, and basically he said, yeah, you're the crook. And he started reading me basically my rights on the phone for the most part, telling me I was the sleaziest person in all America. And his clients were moving back in that property, and basically they would see me in court because I had flim-flammed them out of their house. And I got off the phone with him and called my attorney and told him what was going on. And so my attorney called their attorney. And so then I had to call my tenant and tell them that we had a little problem. How you think my tenant felt? Somebody's gone and broke into his house, it's still his house, and packed up all his stuff and did whatever and put it in one room of the house. So basically breaking and entering the whole 9 yards, but they broke in the house thinking the house was vacant because he kept all the blinds closed. So they thought the property was vacant. And then once they got in the house, they saw the stuff and had to shift gears a little bit. All right. So they sue me. I turn around and countersue them. And so we go through about a 15-month journey and nightmare. That's why I can tell you what I tell you right now. All right. I'm talking from experience. I ain't talking about what you heard, what I heard. So when you start talking to some people that are out here flaunting their wares and telling you about they're the subject to expert, and I don't claim to be one myself, but I tell you what, I know what I'm doing. They claim to be the subject to expert, and they've done all the 4 deals. I'm telling you what, you better watch who you listen to, all right? Because you're going to get yourself in trouble. So basically, end up in court with these people, right? And they're going to nail me to the cross, basically. And so we had to go to mediation before you actually can actually go before a jury trial. So we go to mediation, and I go in there with the mediator, and they had made a demand for what they wanted. And of course, we had made a demand. I wanted my property back. Let me back up just one more second. My attorney got them to do a 30-day stay because the tenant was supposed to be moving out in 30 days, and we were going to try to see what was going to get worked out in that 30 days. So we had to change the locks back, give my tenant occupancy so he could finish his term till he got ready to move out. When he moved out, 2 days later, I ride over to the property in the evening, and there's a U-Haul truck in the driveway. They were moving in when I pulled up. They had broke back in the house. We changed the locks. They had broke back in the house again and were moving their stuff inside the house. I go up to the door, and someone comes to the door, and they kind of bow up at me and tell me ain't no happenings. They were moving in, and so we kind of had a few words right there for a minute. And so I go back outside and get in my car and call the police because this is my house. So I call the police. The police come out to the property. They talk to me. They go to the door, go inside the house and talk to them. And they come back out and tell me, you say you own the property. They say they own the property. This is a civil matter. A judge is going to have to decide. So they get to stay in the house. So, of course, I stopped making payments on it. They're staying there. You got to make the payments now. And so for 14 months, we went through back and forth. We went through me sending all this documentation that I told you about on yesterday and today. We went through me sending meeting minutes. We went through me sending operating agreement. We went through me even sending my bank account information. Listen to me closely. A part of discovery was I had to give them my bank account information. Listen to me. This is a lawsuit. This is why you want to make sure all your stuff, all your ducks are in a row. Everybody don't tell you all this stuff. I tell you the whole story. All right. So I had to send them my bank account information that showed every payment that I made relevant to that property. They want to see every cash receipt I had for the rents that I received over the period of time I had that property. Okay. So went through all of that. All the documents that I told you about, guys, everything to do with my company, they had privy to. All right. Through discovery. Every time I turn around, my attorney was telling me, Tony, they want to see this report. Tony, you're going to have to send that. And I'm like, man, I got to give them that. Yeah, you got to give them that. Remember, this was my first lawsuit. Okay. So I learned all these good daggone, I learned all of this stuff, guys, through experience. All right. Then, okay, we go through mediation. They come to mediation knowing that obviously I got some money and they're getting ready. They just hit the jackpot. Oh, yeah. He's getting ready to pay. So they borrowed money to hire this attorney because they didn't have any money. They borrowed money so that they could deal with me on the premise that it was a lock that they were going to win, so they could pay the money back quite easily because we're going to bust this guy right here. So we go to mediation. They come with some outrageous figure of what they wanted from me, and we're giving them a figure that we want from them. And the arbitrator said, the arbitrator is listening to both parties, and he says, well, to me, basically, you're going to win. I mean, they don't have a leg to stand on. Everything in this paperwork says it's clear you're going to win this. Nobody had paperwork like I had, guys. You're going to win. But they don't know it and they don't believe it because their attorney has convinced them that they're going to win this case. So you guys are like stuck right here. So somehow or another, he went back down in their room and talked to them and convinced them that, hey guys, y'all really don't have a leg to stand on. You're going to spend some more money because this guy right here is going to, more than likely, if this thing goes to court, you're going to lose. So they finally reluctantly acknowledged that they are in a bad position. So now it shifts again. So we're now negotiating how much money they're going to pay me. They didn't want to pay me the figure that I said I needed. And truth be told, I wanted to get this behind me because I told you this Jenny Craig weight reduction program right here just wasn't working for me. So we went on and we settled for an amount. And once we gave them the amount, they actually came back and said, can we put some on it? Meaning that they didn't have any of it. They wanted to put like a small amount of money down on the money, which was very low to begin with. All right. So I ended up $30,000 in attorney fees. Okay. And I recovered some money back, but I didn't recover my attorney fees. So long story short, guys, I had my stuff together, but it still cost me. And that's why I'm telling you all this, because you want to make sure that you do everything properly, that you have your company set up properly. It's important. It's important. It's important. Now, why I won is you're going to see as we get into the documentation that I was using. Okay, because they tried to play like they didn't know that they actually sold the property like that. They claimed that I was just managing their property. That's what they conveyed to their attorney. And what they basically did was they went to their attorney with half of the documentation. They went to the attorney. They took half of the trust paperwork down to their attorney and said that they were the beneficiaries of a trust. Okay. Why could they say that? Let's go back to the screen. I'm showing you why. All right, this is why they could say that. Y'all see it? I want you to look at it closely. The reason they said that is because that trust originally was a trust for them. All right, so when they deeded that property, they deeded a trust that actually had their name on it. Okay. Even though they didn't have nothing to do with it. So they took the paperwork that said that they were the original beneficiaries. They were the beneficiaries of the trust. They forgot to take the paperwork to the attorney that said they assigned their beneficial interests. So you see this part right here? That bottom part where it says beneficial interest with seller? They quietly kept that paperwork at home. So basically what the attorney was looking at was half the paperwork. He saw that they said they had a beneficial interest in the property, and now I was owning their property, and they had all rights to it. And we had already, and through this process, we had sent him documentation to begin with, but he was ignoring the documentation. But ultimately, that's how we won, because we showed them, here goes all the documents, here goes everything that they signed, here goes all the acknowledgments. They knew everything they were doing. Matter of fact, they were a week away from foreclosure, 4 payments behind. We paid $3,600 to catch the payments, to catch the property up, and then gave them $3,000 to walk. Y'all see me getting excited. I'm gonna have to go calm down for a minute. But the bottom line is, this is what happens. This is a part of the subject to process. That's why you got to know that you want to get in where you fit in. Will I do any more subject twos? I've done a gang of them since then. I'm going to do one next week if I can. All right. But what I'm trying to tell you is the whole story. I don't give you a glossy 30,000 foot view, guys. I know some workshops you'll go to, you won't hear them say not one thing bad about this transaction. But that's not how I do it. I want you to know where you're at. I want you to know where I want you to know that as sexy as these things sound, it's a business transaction. You got to know whether or not you want to do this business. All right. So, all right. So these are all the steps, guys. They're going to sign the escrow letter. Let's go back. All right. So we had the seller. Additionally, they're going to cover your behind disclosure form. They're going to execute a limited power of attorney. They're going to also sign a third-party authorization to release information so that you have the ability to contact the bank. We're going to look at all these documents, guys, so don't get all beside yourself. All right. They're going to sign an escrow letter that says that you're entitled to the escrow account. And then you're going to have them sign a letter changing where the insurance is going to be changed. All right. And if they're holding over for any period of time, they'll do a holdover occupancy agreement. All right. Now, how you handle the insurance, guys, that's the next most important part. And we talked about this, and this pertains to you putting your property in a trust, as well as if you actually are taking the property subject to the existing financing. All right. So, as I stated previously, the most likely way for a bank to learn out about the transfer of a property is through the insurance, because oftentimes, guys, what will happen is the insurance agent will screw up the insurance declaration page and send something in that shows that the property's been transferred. I saw you guys in the chat room going back and forth about that a little earlier. So what I'm trying to tell you is what I said previously, if you were listening. The reason that you tell the insurance agent to send you the insurance declaration is so that you can review it and make sure it reads and reflects what you want it to read and reflect. You want to make sure that the policy is set up in the manner that you told him to do it. A lot of times, guys, these guys don't know what they're doing. They're going to screw it up. And if they do the insurance declaration and they put down there that ABC Properties is the name insured, then guess what? You just told the mortgage company that ABC Properties is owning the property. And that's not what you want. The trust is owning the property. So you want to make sure that the insurance declaration is reflective of the trust. And then we're going to name those additional insureds as their interests may appear in the manner that they're supposed to be added. So basically, this is what your insurance declaration would look like in short. This is what you're giving to your insurance company or your insurance agent. So typically, guys, when you took that property subject to, you're going to put your insurance policy in place. You're going to cancel the homeowner's insurance that they have on the policy on the property right now. You're going to cancel that policy. Now, I know some people, I'll leave the insurance in place and let it just sit there because I don't want to cause any problems. It's not going to cause any problems so long as you do it right. And if you have multiple insurance policies on there, that could potentially be a problem down the road. So you're going to make sure that you put insurance in place. Remember what I said earlier, because I've seen investors mess this up because they'll take the property subject to, the seller's insurance is still in place because they don't cancel it and you don't cancel it. And then what happens is if something happens 6 months down the road and the house burns down, I told you already several times, insurance companies are good for two things: collecting premiums and denying claims. The title has been transferred, right? The title has been transferred. At the point in time that property was deeded from your seller to your trust, that's a transfer of title. Your seller no longer owns the property. Therefore, that insurance declaration that they have is invalid. So you have to change the insurance policy. And so going back, that's how your insurance policy is going to be reflected. The Barefoot Indian Scouts Trust, whatever your trust name is. All right. Who your trustee is. Okay. Trustees, your mailing address. And then the insured. A.B. Childers as trustee. All right. And the additional insureds, Joe White and James White. The additional insureds represent the sellers. All right. Some people don't like to do it that way. I do it that way because what I found over the years, guys, is that if I put the seller's name on there anywhere, it just satisfies the bank. They're not going to get any money. They're not going to be involved if something happens to that house. But when the bank looks at that, when the lender looks at that insurance declaration and they see the seller's name, they don't care what else is on there. They want to see the seller's name because that's who they have the loan with. And then going back to the slide, it says, as their interest may appear, as their interest may appear, house buyers LLC. Okay, so that's going to be your LLC or company that you have. That's the beneficiary or maybe managing that property. All right. So this is the same thing, just doing it with a different trust name. Trust name is the Bear Creek Trust. AB Childers as trustee. And the policy would read Bear Creek Trust. All right, your trustee, address, just like we just illustrated before. All right. All right. The rest of what I have, I've actually went into this when I was telling you guys, it's important that you listen. Guys, it's important that you listen because when you listen, you hear. You want to listen to everything that seller is telling you. That's why when you're using that seller lead data sheet, you're on a fact gathering mission. You're listening to what they have to say. And like I said in the video, don't load up on questions. You know, before they can answer one question, you're firing off 3 more. So I'm not going to get all into that because we've been there. I talked about the word pen. You should have that by now. Presentation, education, and negotiation. We talked about the word form, friends, occupation, recreation, and message. Okay, so we talked about doing all that. And then we talked about not getting into a tug of war with these people. All right, we talked about we want them to be on board with us. And I said that you don't want to be push and pull. What you want to have is slack. And I said earlier that slack gets paid. Okay, so we went through that. Now let's go through. We're going to go through why somebody would pay you to buy. I want you to understand that. And then we're going to do the documentation and we'll get ready to take questions and wrap it up. All right. So this is what we use, a projected net equity sheet. All right. Cost to sell worksheet. And so basically, guys, what we're doing here, if you look at this form, if you can see the form, this form that we use in our business, this is how we get the seller to pay us. All right. Because basically what we're doing is we're showing that seller that there is an actual cost to them selling that property. So oftentimes, guys, we can actually get the seller to, we can have the seller to actually give us a number, and we actually agree to the number because we've done our numbers prior to. So what am I saying? What I'm saying is, guys, if the seller's asking price is $140, one question I'm going to ask the seller, I'm going to say, so you, Mr. Seller, you go back to me, Dave. I'm going to say, Mr. Seller, so what I'm understanding, right, is you said that you're asking $140 for the house. Is that what we said? $140? Yeah, we want $140. Okay. Well, let me ask you this. So if a realtor was to bring you a qualified buyer right now, you probably wouldn't accept the offer, would you? And they're going to sit there. It's going to be a moment of silence. And as soon as he says yes, you just knocked off 6%. As soon as he said yes, you're already 6% down. Okay? Guys, you may have heard that in the video already. Don't be afraid of silence. Silence is your partner. Silence is your partner. Ask something. Shut the heck up. Wait for a response. If no response comes, just start doodling if it makes you nervous. Just start writing. Told you, you know, you guys saw on the video, I'm going to sit there, you know, while you ask the question, they're sitting there. You start writing like you serious, like you trying to come up with something. Okay. You're writing. There's still silence. Silence is golden. Silence is working on your behalf. And when all is said and done at the end of the day, that's what you got, right? You were drawing you a smiley face, all right? Because you let that silence work for you. So going back to the form, you get back over here, all right? You're going to convince the seller. This is a part of that education process. Well, you know, if you sold the property at 140, all right, most buyers, if they make an offer, usually you're going to have about a 3% discount off the asking price. That knocks off $4,200. Real estate commission is 6%. In this particular case, that would be $8,148. Average, most buyers are asking for closing costs, 3% closing costs, that's $4,074. And I'm showing them all of these costs, loan payments during the marketing period. Guys, let me let you know something. What we've been seeing lately, guys, we've had a hot market. In years past, typically, guys, average days on market are typically about maybe 4 to 6 months or even longer. So when you're talking to the seller, you're educating the seller on what the average days on market is. You know, nowadays we're seeing property sit on the market, depending on the price point, 30 days, 60 days, couple weeks, they're under contract or whatever. But that's not typically the norm in the real estate market. So coming out of COVID-19, guys, we're going to see some period where we go back and houses are going to sit on the market some. So it's not uncommon to see an average days on market of 6 to 8 months. What you're going to be convincing that seller of is you're the resolute answer to right now. Because even if they wanted to list the property, that's an uncertainty there. You don't know when you're going to sell the property. But I'm here right now, and I'm telling you, just as soon as we can get clear title, we can close this property within the next 7 to 10 days, possibly, maybe even earlier. All right, so we can get this matter behind you. Going back to the slide. So all of these costs right here that you see, these are costs that you can use as many of them as you want or not. Sometimes, guys, I might take the first 3 things, okay, and figure that I've got enough discount off the purchase price that I don't have to nickel and dime and come down here and start doing all this other stuff. You know, because if a buyer goes and gets an inspection, there's going to be a repair request. And you might have some I gotchas on there. You know, come back and found out there's a foundation crack, find out that there's some other issue with the property, and now we're coming back. So those are, I call them I gotchas on there. So if you look back at the screen again, basically what we said in this example is that the seller is subject to have a cost to sell of $40,000. Which means that they're actually going to net $89,000 from the sale. When you take off, when you look at their whole situation, that's what they're actually going to net with all of this cost. Now, when I'm figuring this out, I already know the numbers, but I'm going to sit there with the seller and go through these things line by line, everything that I'm going to use as a part of the presentation to let them see what their bottom line is going to be should they sell this property. So oftentimes, guys, if they're in a seriously motivating situation, then they're going to actually be willing to write a check. Understand that if you're looking at people that don't know that they have any equity in their house, for instance, or they have very little equity in their house and they don't feel like it's worthwhile for them trying to get it cleaned up and listed, if you can go there, that's why I gave you those parameters earlier of where you're looking at houses in a certain year frame, built in a certain year frame, okay? Then when those people don't even know or think they have enough equity to sell, but they may be willing to because now you've captivated them. I got a chance to get out of this house. And so what if it costs me $10,000 or $15,000? Now you've found a way to get yourself into a deal that none of your contemporaries is even looking at, because you were able to convince that seller that you were the solution. You were a problem solver that could help them move on to their next chapter in their lives. All right. So next thing, let's go and look at the forms. So we're going to look at the forms. All these forms are in the book, and we're going to just go through them. All right. And this is a list of all the necessary documents to this transaction. You see a warranty deed to trustee, standard real estate purchase and sales agreement, seller's property disclosure statement, limited power of attorney, land trust agreement with the exhibits A and B, a notice to the mortgage company or insurance, HUD settlement statement. Y'all see all of it. I don't have to go through them all one at a time. All right. Now, so let's go to look at the forms. I'm going to show you, illustrate some to you. Let's walk through. Is this thing going to let me? All right, guys, and you will get all of these forms. All right. So first things first, you're going to have a trust forms list. Okay. On this trust forms list, you can see everything that's in your booklet. All right. Hold on. Is it being displayed? No. All right, just a second, guys. Let me get these forms up for you. I could show them to you in the book, but I want you to see them on the screen, so we'll do it that way. All right, so trust forms list. You're able to see that? These are all the documents that you will get as a part of the workshop. You will get these documents probably Wednesday or Thursday next week. We'll make an announcement to you, because what I will do with you, we're going to do I'm not going to teach this workshop all over again. So let's not make a plan for that. But I will take a few questions, and I'm going to kind of go over documentation with you. And then we're going to send you these forms in a digital format so that you can have the forms and be able to edit them and do what you need to do with them. Most of these forms, or all of these forms really, are in the book, but we're going to just go through them right now. I'm just going to put them on the screen. So these are all the forms that are part of you taking or having in your subject to packet. All right. So you're going to have a document folder, trust forms list. You're going to have your personal property trust, land trust documents, your seller lead data sheet that we walked through, buy, offer, and deal structuring sheet, checklist for buying property subject to and using the land trust, real estate purchase agreement, third party authorization, seller understanding. And guys, I'm just going to kind of go through the documents and sit here and read every one of them off to you. All right. So going through. All right. Everybody saw the land trust agreement before. Same land trust agreement that you use for your property. Same thing you're going to use for the trust, except creating your trust for your subject to property. Same thing, guys. I don't have to walk back through that. We've completed the land trust and we completed the personal property trust. So you have that as a part of your documentation. You have your land trust formation data worksheet. This is what you're going to use to create all the information to formulate your trust. Same thing for your personal property. Excuse me. Same thing for your personal property trust. Personal property trust formation data sheet looks just the same as your land trust formation data sheet, except it's for personal property versus the land trust. All right, and there again is the actual trust document. Seller lead data sheet. All right, so you're going to have the seller lead data sheet with all the questions to ask of your seller. You're going to have a buy, offer, and deal structuring sheet. Guys, this is a great sheet to use. It kind of gives you variables on what you need to do to make certain offers. If the property's free and clear, kind of gives you some solutions to situations, right? Some down payment, seller carries a first mortgage, no payments until sold, kind of helps you think about what you want to offer to the seller. Properties with existing mortgages using land trust, so it tells you might take the property subject to, and the seller pays you some money to buy, all right? And it tells you you might take the property subject to with a first and second mortgage, so it just gives you certain variables there to help you wrap your head around a transaction so you're actually able to execute it. Talks about giving all cash at closing, doing something on an agreement for deed or contract for deed, and you're going to be as creative as you can when you're doing your transactions, trying to come up with something creatively. Again, this is another example of your checklist for buying subject to, all right? So it's going to talk about your due diligence, everything that you need to do so you can read through that, walk through. Of course, guys, this is real estate. We're not just taking everything. Guys, we're still going through a process. We're looking at the seller's documentation. We're getting title searches done. This is a real estate transaction. All right, you got your purchase and sale agreement. All right, so you will have your standard real estate purchase and sale agreement for you to fill out. Third-party authorization to release information. So this is what you're going to get from your seller so that you can contact the bank on their behalf and get information as it pertains to their loan. And guys, usually when you get this form, I recommend that you get 4 or 5 of these in advance. All right, so listen to what I'm saying. Get 4 or 5 of these in advance. Have them sign 4 or 5. You may have them sign 2 or 3 blank copies. Why are you telling me to do that, Tony? I'm telling you to do that because oftentimes a lender will sell their mortgage. And now that Wells Fargo loan belongs to somebody else. And you don't want to have to go back to the seller to try to get authorization again. So you already have them sign the document, and then you can send it in to the respective transferred bank the bank that now owns the loan, and you can talk to them in regards to that property. All right. You got the property loan verification sheet. So guys, when you're talking to that seller, when you get those loan documents, this is everything you're looking at as it pertains to the loan documentation that you're going to get from them, their mortgage documentation, date that it originated, loan origination amount, type of loan it is, maturity date, current interest rate, principal balance, what's the current status, all right? Does it have a balloon? You want to answer all of these questions, okay? Power of attorney. You're going to want to have that seller, and you may have your attorney that closes this transaction for you prepare all this in the manner that they use in your state, but you're going to have a limited power of attorney as it pertains to the property so that you can exercise your ability to manage and control that property. Guys, once you take this property subject to, you never have to go back to the seller. You don't have to go back to the seller to do anything for the most part, unless that seller is bothering you. I'm telling you, when we sold those properties a few weeks ago, we didn't call the seller. We called the bank, request a payoff, and pay off the loan. All right, because we have the authority and ability to do that. Now, this one I want to go over, okay, because I want you to see this one and definitely understand this one. All right, so I'm going to stop here on this one for a second because this is some of the documentation that actually covered my behind when I had that situation that I talked about a little bit earlier. So basically what it says, this is a seller's statement of understanding. All right, So it has the seller's name on there. It says that they've reviewed this form, and after having enough time to think about the terms and conditions, they state the following. Guys, you make sure that they initial each and every one of these provisions. Don't let anybody just take and line through and think they'll sign off at the bottom. They initial every single one. Listen to me. Every single one, they initial. And what it says at the top one, ownership of the property, it says, we are the owners of the property and are able to contract for its sale. There are neither other owners nor anyone else who has interest in the property or who could contest the sale. Acceptance of the offer as presented. It says that they reviewed the offer and they accept the offer, and they say that it is in their they are in absolute agreement to the terms of the offer, the price, and everything, and it's in our best interest. They're saying that, okay, by initialing it. It says that consideration was paid. So basically they say that they have received good and adequate and fair consideration for the sale of their property. All right, and they acknowledge that they received sufficient funding for it. It says that it's in their best interest to sell, and they've evaluated their situation, and they've decided to move forward with selling this property. It says that I am fully informed. I'm not confused, crazy, disoriented, drunk, or whatever, that I don't understand what I'm doing. They're initialing that. Says we are not confused in any way of any aspect of this sale. It says that we are satisfied with the sale price. And we realize that the price is discounted, but it's in our best interest to do so. And we're satisfied. It says that they understand that this sale is absolutely final and that they have no interest, either beneficial or otherwise, in the ownership of the property. All right. Paragraph 8, it says we are not under the influence of any mind-altering substances. So we're not drunk, high, crazy, or anything else. We know what we're doing. It says in paragraph 9 that they have no incapacitating conditions. We're not mentally unstable, emotionally unstable, and we're rational and we're able to make this decision. 10 says we are not under duress. All right, and we're doing this transaction under our own free will with no undue financial pressure. And the buyer has not pressured me in any way. It goes on to say that legal counsel has been advised. And by actually going through with this process, they either chose not to seek legal counsel or they're satisfied that they're able to do it on their own accord. All right, it says that a financial review has been advised and that it's up to them to do so. It says in 13 that this is a formal settlement at closing. This is a formal settlement, and that basically that a deed is going to be recorded and the buyer is going to own that property henceforth. It also goes to say so that if they think that there was a loan, like these people, I don't know what they were thinking, but this is not a loan of any kind. We understand that this sales agreement completes the outright sale of the property and are not intended to be a loan of any kind or for any reason. Says that we agree that this transaction was negotiated fairly. All right, and that the buyer did not take advantage of me. Says we absolutely agree that the buyer is entitled to profit. All right. And you might make a boatload of money. It says, and may realize a substantial profit. Y'all see that? Now they signing and initialing everything. And we're going to sit right there till they sign. Your attorney is having them sign all of this stuff. All right. Your attorney is making sure they sign all of this stuff. No, we don't just line through and sign at the bottom. Their initials will be in each and every one of these provisions and paragraphs. All right. 17 says that no other promises have been made. There's no side agreements. There's nothing else going on. So when they come back 2 years from now and say, well, he told me he was going to do this and that, you ain't told him nothing. All right. It says we are absolutely satisfied with my decision and my deal with my buyer. And my buyer has provided me with tremendous assistance. And we're grateful for his help. Hallelujah. All right, so we good there. That's what you want. You want to make sure they do this, and you can have it witnessed or signed or whatever. But they're going to sign all of these documents. Okay, they're going to do all that. All right, so everybody should be good on that one. The next one, guys, is a due on sale disclosure. You're telling them that there's a due on sale clause in that mortgage. I'm not going to read the whole thing, but it just basically says that they know that you're taking this property subject to, and that basically what it says is that the approximate loan balance is whatever it is, and you're responsible for making a payment continually on a monthly basis. All right, that you're responsible for the payoff, making the payment. You're not assuming the loan. And basically, it also, the bottom part says that we understand that the amortization may run until it's retired. That means, guys, that if you're buying that property, if it's a 30-year mortgage and it's year 5, you got 25 years according to this. You told them up front, we could go the whole 25 years. All right. Now, guys, typically, like I said, if you take something and you go long-term, expect some problems along the way. But you told them, and you didn't make any promises that, hey, we're going to have this out your name next month or in 2 years or a year or whatever. All right. We told them the loan may run the whole entire length. It says that they've had the right to seek legal counsel again. So you're telling them again that they can seek legal counsel. All right. And so now we're telling them more than one time. All right. It says that that the parties have no responsibility to advise the title company assumes no responsibility for seeking a waiver of the provision of the deed of trust. All right, and has not obtained the waiver, and seller and purchaser agree to indemnify and hold harmless the title company or whatever, because you know you're doing a subject to mortgage, guys. So you're just disclosing that. The buyer understands again. It tells you that it tells them in another document that you're gonna make a boatload of money. All right, you're telling them once again. So anytime somebody said, well, they never told me that, you're going to be able to show over and over and over again that, yes, you knew what you were doing. All right. The bottom line, guys, is some of this stuff says the same thing, but we're reiterating it over and over and over again that you signed all these documents because you know what you're doing. Number 6, I have it highlighted and I want to just touch on that a second. It says furthermore, the seller understands and agrees that since the property will no longer legally be seller's, that the seller may not depreciate the property on seller's federal or state income tax returns, nor claim any income tax deduction for owning the property, interest payments, property tax deductions, anything else. Come back to me real quick. Guys, you're going to face this. The reason that provision is in the document, because you got sellers that, let me tell you what's going to happen. You're going to buy their property subject to. You're going to tell them that you're going to transfer all correspondence coming to your P.O. box. So all you're going to do is you're going to change their mailing address to your respective P.O. box. That's all you do. So if their name is John Smith, John Smith's mail is going to start coming to your P.O. box. All right. Now, let me tell you what sometimes happens. Sellers will wait. I've had individuals, I'm paying the mortgage all year long. The payments coming to me all year long. I'm getting the mortgage statements. Come November, December, I don't get the mortgage statement. What's happening to the mortgage statement? We've been getting the mortgage statement. All right. Maybe you don't pay it any attention. Come January, don't get the mortgage statement. So now you make a call to the bank. Hey, trying to find out, we're not getting the mortgage statements for the mortgage. Are you still at such and such address? And come to find out that your previous seller has called the bank and they want the mortgage statements to come to them. Why are they doing that? Because they want to take the tax claim. Listen to me closely. Your seller is trying to claim the interest. They transferred the address back to their names, so to their address, so that they could get the mortgage interest statement, the Form 1098 at the end of the year, because they want to claim the interest. That is not their interest. They didn't pay the interest. You get to claim that interest. I want you to understand something. Internal Revenue Code says that whoever pays the interest can claim the interest. So that may be a point of contention somewhere down the road. If you buy a property in June and you're going to be responsible for the payment from July through December, then you're going to prorate. When you get that mortgage interest statement, you're going to prorate it. You give the seller their portion that they paid prior to you buying the property, and then you take the rest. Unless they don't say nothing, you might end up taking the whole thing. But truth be told, you're responsible for, you're only allowed to report what you actually paid. Okay, so when the seller calls up, well, the loan is in my name, so I figured I could take the deduction. How you figured that you're going to take the deduction? You ain't make no payments. Okay, well, all I'm going to tell you, Mr. Seller, is this. You signed an agreement that you knew that that property is no longer legally yours. Now, we're going to claim that mortgage interest because we paid it. And so when we claim it, of course, when you claim it, you may cause yourself to have an audit. Okay, because we're both claiming the same interest, and one of us is paying it and one of us is not. And that's the end of the story. We move on to the next thing. So I just wanted to bring that to your attention. We can go on to the next thing. All right. Again, it tells them that they're satisfied with the sales price and they realize it's been discounted. Guys, this says a lot of what the same thing. Again, it says that there's no unresolved issues or side agreements, and they're going to sign this document as well. Okay. And this document is actually notarized. All right. Insurance checklist. All right, guys, this is your checklist for insurance. So, and this is how your insurance policy is going to read. We've already gone through that. All right. Of course, you're going to have the mortgage company on there as the lost payee with their mortgagee clause on there that the bank gives you. Escrow letter. I'm not even going to go there. That's just a letter that tells you that you have the right to count, that you have the right to receive the that you have the right to receive the escrow account, any funds that are overage in the escrow account. All right, this is your letter to the insurance company, letting them know that you transferred your title to a revocable living trust. Now, I would suggest you use this for you're going to use this for when you're taking your property, okay? When you're taking and putting your property in a trust. You're just letting you can let them know that they need to have the policy reflected as such. All right. And so you can see all the additional insureds. And if you send them an example, if you fill it out and send them examples, then guys, most of these guys can get an understanding of what you're doing, and then they can get the language there as is required by you. Seller's mortgage disclosure statement. Here, guys, again, is another document. This basically says, again, that basically that they're selling their property and that the execution of the sale may be contrary to the terms and conditions. So basically, this is again saying that you're selling your property subject to the existing financing. It may be a violation of the due on sale clause. We're letting them know again. So we got about 4 documents now that's telling them the same thing over and over, so that when you end up in court in front of a judge, guys, at some point in time, hey, somebody can't say that, hey, I didn't understand what I was signing. You had about 10 opportunities to figure it out. All right. And this is one of the things that actually assisted me when those people were trying to say, well, we didn't know we did all that. Well, all this documentation was sitting there with me with the arbitrator. Okay. That's why I won but didn't win. You don't win when you still pay an attorney $30,000. I got some attorneys in this room right now. They smiling. All right. Addendum to trust agreement. All right. This addendum to the trust agreement, guys, gives you the ability to have a co-trustee. So if you have a trustee, this addendum actually gives you the ability to name a co-trustee. So you might have your best friend or someone else as a trustee, and you want to be able to, in certain situations, to go ahead and act on behalf of the trust yourself. So now this gives you the ability to do that. Sometimes, guys, what usually will happen, you can put the camera back to me, Dave. Sometimes when I get ready to sell a property, let's just say I got John Smith as my trustee, and John Smith is in Arizona, and now I need to sell this property. Well, I don't feel like I may not want to have documents going back and forth to Arizona. So oftentimes what I might do is I might either fire John Smith and appoint myself or appoint my company as the substitute trustee so that we can handle all the documentation in regards to the sale. I also do that because I want the check to come to me. I don't want my check to go to Arizona maybe before it comes to me. But to get around that, what you can also do is you can have your trustee sign all the documentation and then have all the money wired to your bank account. So that works the same way. All right. Just wanted to say that real quick. All right. Going back to the document. All right. So again, this gives you the ability to name a second trustee. All right. To be able to do whatever you need to do in regards to the trust. We went through this document as well. This is the direction to land trust trustee. Remember, guys, what I told you is that you as the beneficiary control and manage the trust. The trustee has a fiduciary responsibility to maintain and conduct actions in regards to that trust on behalf of the beneficiaries, because the beneficiaries are entitled to the proceeds and avails of the trust. All right. So all the profits and all the losses flow through to you as the beneficiary. So this is where you're directing the trustee for any action that he takes. Remember, all actions have to be by written direction. Anything that the trustee does contrary to your written direction, he's violating his fiduciary responsibility and he's putting himself at jeopardy. Remember, the trustee is not at risk in any manner unless he goes and does something frivolous. Now he's got himself in trouble, okay? Because I told you guys, the trustee has the legal right. He could actually go and sell your property, okay? But if he does so, he's gonna be sitting down there, probably meet Mr. Clink Clink. So, you know, that's where he's going from there. All right, but I just want you guys to know that he does have the ability to sell the property. All right. Notification of land trust trustee resignation. This is where you can send your trustee a letter so that he can let you know he's resigning, or if you want him to resign. I mean, excuse me. This is the notice of land trust trustee termination. This is where you're terminating your trustee and appointing someone else. All right. So all you're doing is just a written letter saying, hey, we fired you. It's all good. We still friends. Remember, guys, these guys don't care. He's glad to get fired. You probably had him working. All right. He also has the ability to resign. Come on. Next document. All right. The next one is, this is where the trustee actually does resign. So in this case, your trustee sends you a letter. Hey, says I'm resigning and you need to appoint someone else as trustee. All right. That's no problem. You just appoint another trustee and keep it moving. All right. Next thing and last thing you have in your file is a request for testimonial. So typically, guys, I like to either video these folks, have the closing videoed if possible. We set up a camera and let them go through the motions in there. The attorneys goes through all the documentation and paperwork. And afterward, I like to say, hey, tell us, you know, do you mind giving us a testimonial and tell us how we did. And so then they can stand up in front of the camera and say, hey, Tony was the best thing since sliced cheese. He helped us in this situation. We're so glad. You know, they really, really took care of us. They looked out for our best interests, and I would highly recommend them to anybody. So that when you see them 5 years from now and they say you the worst thing that ever happened, you can play that in court too. All right. All right, guys. So that's the documentation. That is the documentation to the that you will use in regards to the subject to. We're going to do, I'm going to take a 15-minute break, and then we're going to finish this up with one last thing, and then I'm going to take some questions, guys, and that's going to be it. So let's take, matter of fact, not 15 minutes. Let's take, let's be back in 9 minutes. So let's take about an 8-minute break. All right, guys. See you in 8.